detention spaces lack strict preventive and external oversight. The issues in our detention facilities, such as severe overcrowding, prolonged pretrial detentions, and institutional friction, are well documented by both local bodies and international experts. These deficiencies do not just complicate regional management, they systematically erode dignity. Preventing torture is not just about prosecuting a perpetrator after an abuse has occurred. It is about transforming their environment of detention entirely. It means evaluating custodial policies, addressing the root socioeconomic and cultural triggers of institutional violence, and ensuring that no corner of any penal institution remains hidden from the light of accountability. This is precisely why the Committee on Human Rights has readily collaborated with this dialogue initiative of the Commission on Human Rights. We are here to bridge the gap between our international commitments and our domestic codification. Right now, in Congress, House Bill 3047, authored by Representative Bienvenido Abante Jr., House Bill 6662, authored by Representative Rufus Rodriguez and Maximo Rodriguez, and House Bill 6666, authored by Representatives Rufus Rodriguez and Maximo Rodriguez on the NPM, are undergoing intense committee scrutiny. As a subcommittee chair on NPM, I'm honored and humbled to be a part of the legislative process that would facilitate and ensure the passage of the proposed bills. In this high-level dialogue, we anticipate a productive, substantive exchange of information and expert opinions on the structural autonomy of the NPM, on drafting a harmonized interagency cooperation with law enforcement, and integrating global best practices drawing from the technical expertise of CHR, UNHCR, and the APT. As we have also have with us the former UN Special Rapporteur on IDPs, Attorney Cecilia Jimenez. To my fellow legislators in attendance, our presence here is a statement that human rights are not secondary to national development. They are the bedrock of it. The enactment of the NPM law is a moral imperative that will elevate the Philippines' standing in the global human rights community. Let us use this dialogue to resolve the remaining contentions in the subject bill that is under deliberation by the subcommittee, harmonize the perspectives of our state forces and civil society, and accelerate these bills to the plenary floor. To our international and institutional partners, thank you for keeping the pressure on, for providing the necessary blueprints, and for remaining in the trenches with us. Your critique makes our law stronger. Your partnership makes our institutions safer. Thank you very much. Welcome once again, and I look forward to an actionable, productive, and historic legislative exchange. Mabuhay kayong lahat.
Attorney Jill to introduce our next speaker.
Yes, thank you very much, ma'am. And thank you very much, Congressman Roman, for your message and for your steadfast support, as well as for representing the House Committee on Human Rights in today's dialogue. Maraming salamat po, Com. To further set the tone for today's engagement, may I now invite our chairperson, the chairperson of the Commission on Human Rights, Chairperson Richard P. Palpalatok, to deliver his welcome remarks and the activity overview.
Thank you, Jill. To Representative Antonino B. Roman III, distinguished lawmakers from the House of Representatives and our co-host from the House Committee on Human Rights, esteemed international partners from the United Nations and the Association for the Prevention of Torture, colleagues, ladies and gentlemen, magandang hapon po sa ating lahat. Welcome to Kongreso para sa Preso. Today's dialogue reflects our shared commitment to upholding human dignity, strengthening accountability, and advancing the protection of human rights within all places of deprivation of liberty. This June, the international community commemorates the International Day in support of victims of torture. It has also been 14 years since the Philippines acceded to the optional protocol to the Convention Against Torture, or the OPCAT, in 2012. Yet, despite this commitment, the country remains non-compliant with one of the OPCAT's core obligations, that is the establishment of an independent national preventive mechanism, or NPM, through enabling legislation. Through the visitorial mandate of the Commission on Human Rights, we continue to witness firsthand the realities inside the places of deprivation of liberty, most notably the severe overcrowding in custodial and detention facilities. Such conditions heighten vulnerabilities, increase the risk of cruel, inhuman, or degrading treatment, and underscore the urgent need for stronger preventive safeguards. Monitoring places of deprivation of liberty remains vital. However, monitoring alone, without a legislated and empowered NPM, limits our ability to institutionalize prevention and address systemic issues before violations occur. This is precisely why today's dialogue matters. We have designed this session not as a one-way presentation, but as an open and collaborative exchange organized into two key segments. First, we will hold expert briefings where our international partners and the Commission's Policy Linkages Office will share global best practices and provide a clear understanding of how national preventive mechanisms operate in practice. Second is the open forum, the heart of today's engagement. We hope to hear directly from our lawmakers and legislative staff your questions, concerns, insights, and recommendations regarding the proposed NPM framework and the pending legislative measures. Allow me to emphasize that an NPM is not intended to be adversarial to custodial authorities or detention administrators. Rather, it is an independent preventive mechanism that reinforces accountability, promotes professional detention management, and ultimately protects human dignity. Today is an opportunity for us to listen, engage constructively, and work collectively toward a common path forward. Thank you to the Committee on Human Rights Chairperson Bienvenido Abante and the House Committee on Human Rights for opening the doors of Congress to this important conversation. Our gratitude extends likewise to the Embassy of Netherlands for supporting this legislative dialogue and the Commission's effort to lobby for its human rights legislative agenda. We look forward to a productive and meaningful discussion this afternoon. Maraming salamat po.
Thank you very much, Chair. Before we begin, we'd like to acknowledge, of course, the presence of our distinguished guest from the House of Representatives, of course, Congressman Antonino V. Roban, Vice Chairperson of the Committee on House of Representatives Committee on Human Rights, Honorable Jonathan Keith Flores, Honorable Ricardo S. Cruz, Honorable Rene Luisco, and Honorable Sarah Jane Elago. Maraming salamat po sa inyong pagdala, ma'am, sir. Again, we'd like to reiterate our sincere appreciation to the House Committee on Human Rights for providing this valuable opportunity for a dialogue and engagement. We thank the committee for demonstrating its commitment to legislative reforms that protect and promote the rights of Filipinos, including persons deprived of their liberty. Your partnership in advancing human rights legislation is vital in ensuring that our institutions remain responsive, accountable, and faithful to the principles of human dignity. We hope that the conversation this afternoon will contribute meaningfully to the ongoing legislative efforts to establish a Philippine National Preventive Mechanism. And now, to proceed with the substantive sessions of today's program, our first presentation will situate today's discussion within the broader international human rights framework. The prohibition of torture is among the most fundamental and non-derogable principles of international law, yet the challenge remains: how do the state ensure that this prohibition is translated into effective safeguards and preventive mechanism? To discuss the global standard for prevention of torture and the role of international human rights mechanism, we are pleased to invite Ms. Maricen Santos, Head of International Obligations Monitoring Division of the Commission on Human Rights Policy Linkages Offices. So to discuss the international human rights context, may I present Ms. Maricen Santos.
Thank you, Attorney Jill. Good afternoon to the honorable members of the House of Representatives and also honorable Chair, Commissioner, and senior executive officials of the CHR. Thank you, Attorney Jill, for providing a brief overview of my presentation. I won't delve into definitions or the international humanitarian law and international criminal law, but I'll focus on generally on international human rights mechanisms. Because as you know, as the human rights culture has evolved, the meaning of torture has expanded to include conduct that the authors of the earliest declarations and legal instruments may not have specifically anticipated. This is a positive development as the ICRC commentary on the Geneva Conventions observes a narrow definition that attempted to list every forbidden act would merely challenge the seemingly limitless inventiveness of torturers rather than offer real protection to victims. Next slide. So this is just how we see the core international human rights treaties between thematic issues and populations. So there are 9 core international human rights treaties with 10 treaty bodies monitoring these international human rights law. So basically, as Attorney Jill has mentioned, the prohibition of torture under international law is absolute and non-derogable. Torture is never permitted, whether in times of war, public emergency, or terrorist threat. The rule is firmly established and widely recognized that it has become a fundamental principle in our international law studies, use cogens or peremptory norm under customary international law. Basically, it means even states that have not ratified treaties specifically banning torture are still forbidden from using it against anyone, anywhere. This also means that it is a norm from which no derogation is permitted, so that any treaty or national law purporting to suspend legal obligations in the prohibition of torture would be void. So before the Convention Against Torture in international human rights law, we begin with the Universal Declaration of Human Rights under Article 5. No one shall be subjected to torture or cruel, inhuman, or degrading treatment or punishment. And then as the International Bill of Human Rights was established, ICCPR, the International Covenant on Civil and Political Rights, together with the ICESCR, or International Covenant on Economic, Social, and Cultural Rights. In ICCPR, we have Article 7. No one shall be subjected to torture or to cruel, inhuman, or degrading treatment or punishment. And there's also Article 10.1 on related to this to interpret on the deprivation of liberty. And then, of course, when the Convention Against Torture was adopted in 1984, it further expanded the scope on no exceptional circumstances whatsoever, whether a state of war or a threat of war, internal political instability, or any other public emergency may be invoked as justification of torture. As the international treaties on different populations or thematic issues have been adopted. Next slide. There are also articles in those treaties that mention torture or prohibition of torture or protection on articles pertaining to the prohibition. Next slide. So in terms of other treaties on populations and thematic issues, CRPD, CERD, ICESCR, among others, have indirect provisions. And these international treaties should be interpreted together in terms of reviewing or monitoring the compliance of the Philippine government with the treaties it has ratified. Next slide. So we always present this organigram to also show how interconnected the treaty-based bodies and charter-based bodies are, and how the Commission monitors the compliance of the Philippine government. As I've mentioned, there are 10 treaty body mechanisms monitoring the 9 international human rights treaties. I won't delve into the SPT and OPCAT as Ms. Sina Paulsen will discuss about that. On the charter-based bodies, later on, I'll show you other non-binding but also important international mechanisms that monitor Philippine government compliance. Next slide. So the Convention Against Torture was adopted by the UN General Assembly on 10 December 1984 and then entered into force on June 26, 1987. So basically, the treaty body of CAT is composed of 10 independent experts. So all of these treaties that the Philippine government has ratified, the Philippine government delegation are being reviewed. That's the final review in Geneva, the interactive dialogue. But then in the process, during the cycle, the Philippines has to submit periodic reports every 4 or 5 years, depending on the schedule of the UN as well. So on the articles of the Convention Against Torture, these independent experts, they review the compliance of the Philippine government as the Philippine government submits their periodic reports. And then besides the periodic reports of the state party, the treaty body also interpret different articles of the convention through their general comments. We can also conduct inquiries and receive complaints in appropriate cases. Next slide. So this is just a map from the OHCHR of the ratification status of the Convention Against Torture. 175 state parties as of April 2026. Next slide. So as I've mentioned about the Committee Against Torture, they are the experts in reviewing the compliance of member states to the treaty. Next slide. Sorry, I'm like speeding through. I'm conscious of the time. Also, next slide, Sina will cover that. The optional protocol on the Convention Against Torture, as of April 2026, relatively ratified by 96 member states, and of course the Philippines is included in the state party. Next slide. So this is just a reporting summary of the Philippine government submission to the requirements of each of the treaty bodies. I will highlight that. So the last interactive dialogue of the Philippines was in 2016. In 2017, the Committee Against Torture requested for the state party to submit a midterm report to update on, among others, pretrial detention, jail congestion, among others. I think the Philippine government, they were able to submit to the committee, but not in the midterm reporting on those specific concluding observations, but for the upcoming periodic report already. So the Philippine government submitted on 21 June 2022, and the implementing agency for CAT is the ILG. And of course, the other attached agencies need to contribute to that report. We haven't heard from the OHCHR yet, or the treaty body, on the next interactive dialogue of the Philippine government. But as we analyze the reporting schedule, the Philippines, they've been subjected to interactive dialogues with many treaty bodies beginning in 2022. So we can also see that the next periodic interactive dialogue will also happen at the same time, either 2028, 2029, as you can see in the calendar. For CAT, we will also update you on the interactive dialogue of the Philippine government. Next slide. So I mentioned about those are the binding treaties that has to be also codified into national law or interpreted into the national context by the member states that have ratified. But then the soft law or the non-binding mechanisms or principles, and we've heard about this, the Mandela Rules, the Istanbul Protocol, among others. They are useful guides for investigation and monitoring, particularly in different places of detention. So the CHR refers to these manuals as well in conjunction with the concluding observations of the Committee Against Torture and, of course, the SPT. Next slide. And then we would like to highlight the role of the special procedures or the special rapporteurs. We have a former special rapporteur, Attorney Cecilia Jimenez Demery, on this role of the special rapporteur on torture and then the working group on arbitrary detention. So they're part of the UN Charter-based bodies, although their reports are not binding to the country that the special rapporteur has visited. There is moral suasion and also pressure for the state to respond to these recommendations and findings of the special rapporteurs. So currently, the special rapporteur on torture is from Australia, Jill Edwards, and then the working group on arbitrary detention. In their country visits, similar to how the SPT conducts their visits as well, but their reports are submitted to the Human Rights Council. It's also significant, though, their reports are also either quoted or referenced by the treaty bodies. So in this instance, either the Committee Against Torture or the SPT or the Human Rights Committee or the treaty body for ICCPR. Next slide. So I'd also like to highlight the role of the CHR, because the CHR is a national human rights institution. The CHR is created by the 1987 Philippine Constitution, as you know, but we also have a international mechanism that we follow and we adhere to, the 1993 Paris Principles that govern all national human rights institutions, and we have to make sure that we comply with them to ensure that we are A status, meaning we meet all of the criteria of the Paris Principles, being an independent national human rights institution. We have a broad mandate to promote and protect human rights and also conduct reporting, monitoring, investigation, among others, and independence in terms of in operations. We can be considered a state-based non-judicial mechanism as well. So we are from the policy cluster. So our role is to monitor the compliance of the Philippine government in all of these treaties that I have glossed over. So we also submit independent reports to the treaty bodies and the charter-based bodies. We assist and advise the different branches of government in the ensuring that the concluding observations and the international mechanisms of the UN are being adhered to. And that's through our position papers that we submit to both House and Senate, and also our advisories and independent reports and situation reports. So that's basically my presentation, and Sina will specify the SPT and OPCAT.
Thank you very much, Marison, for providing us with a comprehensive overview of the international human rights context, which will guide us eventually on our efforts to prevent torture and ill treatment. Before I proceed, I would like to recognize, acknowledge the presence of Congressman, House Representative Kenneth Gatchalian from 1st District City of Valenzuela. Maraming salamat po, sir, for attending our dialogue this afternoon. To proceed with our next session, As we mentioned earlier, the Philippines became a state party to the optional protocol for the Convention Against Torture in 2012. However, up until today, the establishment of the National Preventive Mechanism remains a key obligation awaiting full implementation. So to help us better understand the treaty requirements under the OPCAT and the role of the United Nations Subcommittee on the Prevention of Torture in supporting state parties, we are honored to hear from Ms. Sina Paulsen, the Senior Human Rights Advisor of the United Nations Office of the High Commissioner for Human Rights. Ms. Sina?
Thank you very much. Honorable Representative Kenneth Battalion, other members of the House of Representatives, Honorable Chairperson Richard Papalato, and Vaida Durmarpa, Commissioner and Executive Director. Thank you so much for having me here and for being at this meeting. It's really quite exciting for us that this is happening and that we have an opportunity to talk about the National Preventive Mechanism, the optional protocol. Because as was mentioned earlier, the Philippines ratified this treaty some time ago, and there was great optimism, and actually the Philippines being an early ratifier in the Asia-Pacific region, we have a great chance, I think, a great opportunity to set up something that's the gold standard in this region for preventing torture. I will also say, now that Marison has gone over the very complicated infrastructure of what the human rights, infrastructure globally is, the optional protocol is the good news is it's a very short document. It's probably, I would say, one of the on the surface at least, simplest documents. It asks the member state to do just a few things. Of course, the devil is always in the detail, but it just simply asks to prevent torture by setting up a national group of people who will have the right expertise and allowing access at the international level once in a while for a subcommittee to come. It's not so complicated, more complicated than that. Of course, they need to function well, and this is what we are going to talk about looking forward. So what I will do today is talk about three things. First, the OPCAT framework and how it works. Then look into some of the key obligations, and then clarify the role of the subcommittee on the prevention of torture, which is the international mechanism. I will touch briefly on the national preventive mechanism, but since the Association for the Prevention of Torture has a lot more detail on that, I will also leave that to Attorney Jimenez. So if you go to the next one already. Yeah, here. So the OPCAT, what is the OPCAT? It's a human rights treaty. It's an optional protocol to the Convention Against Torture, which means that states parties who already ratified the Convention Against Torture can do this as an add-on, can ratify this, which was done by the Philippines and many other countries. The OPCAT was developed. It was very innovative when it was developed back in 2002. And it really grew out of a frustration that in human rights we tend to look at things and talk about everything that's gone wrong, rather than perhaps trying to prevent things from before they happen. And the OPCAT is very much a reaction to that. So what the OPCAT focuses on is preventing violations before they take place, through putting in place systems that make it easy to abide by human rights. What does this mean? It means a system of monitoring where independent monitors can identify risks, recommend improvements, and give, advice and have constructive dialogues with state actors, with prisoners, with civil society, with other relevant parties, before the possible future torture occurs. I mean, hopefully it would not occur, right? So it's preventive. And the scope is very broad. We talk about prevention of torture. The first thing that comes to mind is prisons and jail cells and police lockups. But the convention is quite clear that the access or the scope is much broader than that. It includes any place where a person could be legitimately thought to be involuntarily detained. So it can include psychiatric wards, for example, drug rehabilitation centers, police stations, hospitals in some cases. All of these places fall under the scope of the optional protocol. And then there is a separate, and the last point on this slide is a separate requirement that this mechanism, the national preventive mechanism, is established by law. Why? Because it makes it, one, because it shows a clear commitment by the government, but it actually also makes it much more difficult for anyone who might want to do so to mess with the independence of the national optional protocol. So there you have it. These are the key requirements under OPCAT. So what can we say more? The prevention objective is based on this. It emphasizes continuous prevention, addressing systemic or systematic conditions in detention. So it's not so interested on individual cases or on individual incidents that occur, unless they keep occurring, because then it becomes a pattern that can be addressed. But it's more about, for example, looking at risk factors. So what are risk factors that an OPCAT mechanism, whether it's the National Preventive Mechanism or the Subcommittee on the Prevention of Torture might look at? Things like overcrowding. Where you have overcrowding, automatically there is a greater risk of torture or ill treatment at least. Inadequate training of prison officials. This is another one. It's quite easy to address if we know there is a lack, but for a subcommittee to be able to look at the training modules, are they good? Are they up to date? Do they reflect the latest research? And then there are many other factors. Lack of oversight, lack of confidentiality of interviews, for example. These are the kinds of things a committee will look at. It will not go and investigate individual prisoners and the kind of complaints they might have. For that, of course, you can have other mechanisms, and you should have other mechanisms like investigative bodies of the Commission on Human Rights or of other mechanisms you might have in the country. So those are the kinds of main things. And how does it do it? Through mandated visits and dialogues, regular constructive dialogues on improvement, reporting, and promotion of international standards. Okay. So that's sort of the main thing we ask as a states party on the OPCAT. So if you go to the next one, what are we asking states to do? First of all, to establish this preventive mechanism, which is what we're trying to do with the current bills that are being promoted. So states who've ratified the OPCAT, the optional protocol, are obliged to create or designate national preventive mechanisms to monitor places of deprivation of liberty. All those places we listed. And to do that, states must provide comprehensive data on detention facilities and persons deprived of liberty to the bodies. I'm sure that will be discussed further. But in order for the national preventive mechanism to know where to visit, they need a full list of the places they should be visiting. It doesn't mean they will visit everywhere, but at least they will know all the places. Cooperation and protection. States should show willingness to cooperate in good faith with these bodies. And importantly, and this is also part of the OPCAT, provide protection from reprisals for anyone, whether it's a government official, an independent actor, a victim, who provides information to the OPCAT committee, to the National Preventive Committee in this case. And finally, the state party must allow access to this to the SPT, the Special Committee on the Prevention of Torture, which is the international level body. So these are the kind of things we request from the states. Of course, connected to that, there must be, yeah, exactly, confidentiality in the monitoring visits. So confidential handling of information, protect detainees and staff, encouraging honest communication without fear of retaliation, always in the visits. So in the law, for example, you would have provisions for this. There must be access to detention areas. That means unannounced visits to all areas, wherever they happen, because that's the best way of ensuring independent monitoring. Transparency through the reporting. So actually the OPCAT, the optional protocol, requires annual reports by these mechanisms, by the national mechanism. And balancing confidentiality with transparency. This is the one that's a little bit more, that can be a little bit more tricky sometimes, because you want confidentiality to get the full scope of information, but also for recommendations to be useful and implementable. Of course, there needs to be transparency about what those recommendations are, who can implement them, and to some extent, although not on an individual level, you know, what they're based on. So that there is a sort of body of information that needs to be made available throughout the process here. And very quickly, the National Preventive Mechanism, what we require from it, and we will, Attorney Sedge will go into details on that, but independence is the core thing that we are really looking for here. A clear mandate aligned with the OPCAT provisions, and functional autonomy. So it shouldn't be connected to other bodies just because that way it can act on its own. We also look at the particular composition. So we need experts, legal experts, medical experts, people who worked in detention settings before, all of these, as well as those with expertise on different vulnerable groups, so children, women, that kind of composition. Transparent appointment processes. Consideration of gender balance is specifically mentioned in the OPCAT. Adequate funding and staffing, this is also somewhere where the legislative branch comes in, but it's quite clear that there needs to be a proper budget for it to be able to function in reality. Access to documentation and the ability to have private interviews in settings of detention. But this is just a very brief overview. We'll come back to some of these later of the national mechanism. So all of this is the mechanism that would be set up at the national level, consisting of Philippine nationals and actually working kind of without interference from the international system. I will get back to the relationship between the two, but that one operates, you know, on its own. Then the next one, the subcommittee on the prevention of torture, because this one I think is really important to understand. This is where the international aspect comes in, and this is where sometimes there can be some reservations. But I would say the important thing here is that the subcommittee on the prevention of torture, it's already working, and it's already doing what it's been doing in the Philippines. So it's already had 2 visits here, one in 2015 and then the second one in 2024. And I have to say that the last one in 2024 was considered a very successful visit, in the sense that the subcommittee, the members who came, were able to actually visit almost every single one of the places that they asked for access to. And you think this is simple, but actually I think from the government's perspective, this is quite a big achievement, because it means that, you know, you have to be able to inform every police lockup in every little police station in every remote area that if these people show up, they're supposed to have access. So logistically, it's a quite big undertaking, but it worked, and I think the subcommittee was very appreciative of that. So next one, the country visits is a key, is probably the pinnacle of the subcommittee's work, and that's the one we know about because that's when we see them here. But they work all year, of course. They visit many countries. They are made up of 25 independent experts with different expertise, I mean, in a way mirroring the national mechanisms. They have legal, they have gender balance, they have medical expertise, all of these, but also with geographic balance. So you have each country, actually, each country that's ratified the OPCAT can nominate members to be part of this SPT committee, and then you can maximum have one from every country. So they try to have quite good regional balance since there's 25. In terms of visits, it's not all 25 that come. It's usually, depending on the size of the country and other factors, a certain group of people. I can't actually remember how many came to the Philippines. Three or so. So they go. But, you know, clearly the more people arrive on these visits, the more places they can cover. And they did sort of split up and go to different parts of the country last time. But other than the country visits, they also serve as advisors to the national preventive mechanisms in a cooperative way. And I think very much it's a two-way process because at the international level, it's always a learning process of what works on the ground as well. So you may have a very nice optional protocol with ideas for how things should work, but in reality, there are many lessons that are learned from the ways the NPMs that have been set up have been working, and the Commission on Human Rights has also engaged with the subcommittee to look at how it could work or what could be working in the Philippines, but also to draw lessons from other countries on how do you avoid some of the pitfalls that can impact on access, on unannounced visits, or on, you know, the full scope of the work on the NPM. What are the size? In some places, it's connected to the National Human Rights Institute. In some places, it's a standalone body. How do you appoint commissioners? All of these things are things that the subcommittee on the prevention of torture can provide advice on. Of course, you also have specialist civil society organizations or international organizations like the APT who will provide such advice too. This is my final slide almost. So, yeah, sorry, this is almost the same of what I just covered. So, yeah, sorry. I think I've covered most of this, other than possibly the capacity building area. This is important because when a new NPM is established, there are opportunities to get quite a lot of technical support from either the international organizations or from the subcommittee or from the OHCHR presence in the country to set up any kind of technical support that would be needed. Luckily, in the Philippines, we have quite a lot of experience in the Commission on Human Rights already because they were doing the work already as an interim NPM. But nevertheless, it can be a good opportunity. It can also be a good opportunity for collaboration, for example, between different countries in the region or these kinds of exchanges as well. Final one, relationship between the SPT and the national preventive mechanisms. Like we said, it's a cooperative and two-way relationship. What the subcommittee, the international level committee, is not supposed to be is a supervisory body. It doesn't supervise the national preventive mechanism. The national mechanism decides on its own work plan, does its own work, and implements as it finds reasonable or as it has resources to, and then it can consult the SPT at the international level if there is a particular question or problem. SPT can help develop effective methodologies, modalities, and also, if necessary, help safeguard the independence of the national preventive mechanisms through providing models. It can engage in dialogues. We have every year many international dialogues on torture prevention because it's a very important topic. And finally, just on the legal side, what we do expect is that the National Preventive Mechanism and the Subcommittee on the Prevention of Torture would be able to have free communication. Not so much an issue in the Philippines, I know, because there's a lot of engagement between international and national mechanisms, but in some countries this engagement can also be sensitive. I have just one more slide, and it relates to the implications and responsibilities for legislators since we are here. The first step is to make sure that the legislation is sound and that it's fully compliant with the OPCAT. For me, this is, once that's done, half of the work is done. That's not really true because there are people who have to implement. But let's say that is really fundamental, and it's something that I think we have a very good foundation for in the bills that are there already, actually. The other core area then, once we have the legislation, is, of course, oversight and resource allocation. In some countries, the lack of resources can become a major obstacle to visits, to implementation, to outreach, to all of these things we expect the NPM to do. So the legislatures, certainly in the budget process, can play a really important part there. And finally, promoting a culture of prevention. So we don't want to see cases. We want to see prevention, promoting prevention as a part of good governance, and proactive engagement on these reforms, this outreach, in the various messaging that's done through the legislature. But again, let's say these are not enshrined, other than the OPCAT, compliant legislation. The other ones are not exactly part of the OPCAT protocol. They're just what we consider good practice and what we hope to see. So with that, I will finish, and thank you very much for this.
Thank you very much, Sina, for highlighting the importance of preventive monitoring system in fulfilling the international commitment, especially in protecting persons deprived of liberty, and also assisting places of deprivation of liberty in improving their systems and processes. To continue our discussion on the National Preventive Mechanism, around the world, there have already been several NPM that have been established. Their experiences offer valuable lessons on independence, effectiveness, cooperation, and accountability. So to discuss practical models and best practices from different jurisdictions, we are privileged to have with us this afternoon a board member of the Association for the Prevention of Torture in the Philippines, who has also previously served as the United Nations Special Rapporteur on the Human Rights of International Displaced Persons, and has extensive experience in international human rights protection and institutional reform. Ladies and gentlemen, to discuss the best practices in NP implementation, Attorney Cecilia Jimenez Damari.
With your permission, Chair. Good afternoon. Thank you very much for giving me this opportunity to be a resource person in this esteemed Human Rights Committee. So I give commendation to the Honorable Chair, Kenneth Gatchalian, and also the other co-chairs and members of the Human Rights Committee, and of course the CHR Chair, Richard Palpalatok, and Commissioner Feida Maniri Dumarva. Esteemed members of the committee, CHR officials, and other legislative staff. It's really my pleasure to be here. I have been asked to provide a sharing concerning the best practices in national preventive mechanisms worldwide, and practically all the strategic and some strategic frameworks for the effectivity in the operation of the NPM. I think, as Ms. Poulsen had mentioned, the optional protocol for to the Convention Against Torture is actually one of the shortest treaties ever. But I can tell you that it was actually discussed for 10 years. The last 5 years of which I was the civil society representative to the Commission on Human Rights for the drafting, the negotiation of this committee. So you can just imagine that me, as a Filipino lawyer, I have this in my heart. It was my first international human rights project ever after my LLM in the UK. So since then, I have been involved in the prevention of torture, coming, of course, from also my experience in the Philippines before I became an international lawyer. Next slide. So here you will see the optional protocol Convention Against Torture trends. And the blue line presents you the signatures, which are going up. Same with the ratification. And the red one is the establishment of the National Preventive Mechanism. And we in the Association for the Prevention of Torture is, of course, practically function, not merely as an observer, but also promoting prevention of torture worldwide. And I would like to invite you, of course, to visit our website. And we have operations and monitoring and actually very practical advice to national preventive mechanisms. I have a little story to actually share with you. In the beginning, the OPCAT, which we at that time called the Draft Optional Protocol, was only concentrated on setting up an international visiting mechanism. But reality hit hard when we realized that an international visiting mechanism can only visit one country that has ratified the protocol, maybe once, twice in 5 years. And so we came up with the idea, which actually eventually gained the support of the international community, that actually visits are more effective if they are done at the national level by people from that country with expertise. And this is how we came to come about and include in the OPCAT, in those last 5 years I was in the negotiation period, this idea of a national preventive mechanism. So here you will see that national preventive mechanisms have been on the rise, really going along the ratification process. So, of course, there are different forms of national preventive mechanisms, and this can be like the Commission on Human Rights also visits, the Ombudsman, all have the power to visit places of deprivation of liberty, including unannounced, to have interviews and access documents. The judges also can do this. They can also publish reports and recommendations. But what is very unique about the NPM is that it is their only job to visit places of detention. There's nobody else that can do so with the expertise and with the independent and people with integrity who can do so, who are nationals of the country. And secondly, national preventive mechanisms is also based very specifically on a law that will be hopefully drafted, negotiated, and finalized, in the House of Representatives and eventually in the Senate. Next slide. So when it comes to the national preventive mechanisms, the trends are very global. These, the blue line are actually represent the new and specialized. So really entities that were set up specifically to be NPMs. The one, it's the other way around. The one on the top is actually the NHRIs and ombuds men or persons who are also the national preventive mechanisms. So, for example, the Commission on Human Rights, through a very specialized unit of the Commission, can function as an NPM. But there is also what we call the new and specialized, and that's the dark blue line, where these are NPMs that have been established specifically for that, independent from any other institution. And the last but not the least, the red one at the bottom, are actually multiple bodies. And we have other countries like Canada who actually have this. And most of the time, these multiple bodies are very appropriate for federal jurisdictions, which we are not. Next slide. So across the Asia Pacific, just a few examples of where there are multiple NPMs would be Australia and New Zealand. And in other countries like Maldives, Sri Lanka, Mongolia, Kyrgyzstan, and Kazakhstan, these are the national human rights institutions who function as national preventive mechanisms. Next slide. So regardless of the model, the question of strategy and the added value is of immense paramount. Of course, it is important that it complies first and foremost with the text of the optional protocol for the Convention of Torture. But there are actually key questions that need to be answered, be it in legislation or the rules and regulations or the internal rules that have to be taken into consideration. First of all, how does prevention add to what's being done already? How will visits actually reinforce or even have an added value to everything that's happening? I think it's very important what Ms. Poulsen said, that national preventive mechanisms are not there to really point the finger to specific cases or even people. What is important is really to look at systems that will prevent torture. Second question is how to choose between places defined by Article 4. Article 4 of the optional protocol for the Convention of Torture is actually a very important article because it defines who are persons deprived of liberty. It defines what are the places of the deprivation of liberty to which the subcommittee and the National Preventive Mechanism can actually and should have access to. Optional Protocol 4 is the subject of the very first general comment of the Subcommittee on the Prevention of Torture. And it really, that general comment in interpreting what Article 4 is all about, provides that the interpretation of Article 4 should be as comprehensive as possible. Again, like Ms. Poulsen said, it's not just prisons. It can be any place of detention under the control or jurisdiction of the state. So this can include psychiatric hospitals, this can include orphanages, this can include places of rehabilitation, administrative detention. It can even include, and we had a big debate about this, it can even include places of transit where people who have been arrested will be transferred to another more permanent place of detention. So Article 4 is very key in understanding what are places of detention. So, and these can be public, these can be private. Last but not the least is how to ensure that visits lead to change. So the problem sometimes is that NPMs may be tempted to visit just because you need to visit, just because you have a budget, just because there's a schedule. But no, the visits are supposed to be opportunities to change in reference to the system that governs places of detention. And this definitely, therefore, includes the fact that the NPMs, because they're in the country, this is what an international body cannot do. Because they are in the country, NPMs can actually follow up the recommendations that they have made. And they have also been in a position to develop networks, who to talk to, who to visit, and where the nudges can actually be effective so that reform and change can be effected. Now, there are three ways that NPMs have approached this. First of all, let me just show some visits. To give us an example, Costa Rica has been very good. I remember Costa Rica during our numerous meetings in the United Nations Commission on Human Rights. Costa Rica with Switzerland was the co-chair of the working group that was negotiating this treaty. And so it was very obvious they would be one of the first that will really, that's really in the forefront of prevention of torture. So here you will see that they have visited a wide range. The NPM of Costa Rica has visited prisons, police, court cells, psychiatric hospitals, migrant detention, of course, it's important for them, child welfare, aged care, okay, where the elderly are, and even judicial detention. Next slide. And out of these come reports. So it's not just the visits. The NPM actually issues reports. And unlike the reports of the international mechanism, the reports of the National Preventive Mechanism are public. They are actually public for, for mass consumption, and also so that those who need to know would be able to work on that. And of course, the government is encouraged to act on them. And the reports here, you can see with Costa Rica, are on themes. So they issued a thematic report for the people with mental health in conflict with the law. They also had one on intra-prison violence. And last but not the least, that I would like to cite is care for people with mental illness as well, with more really focusing on the vulnerable. Next slide. So Norway visited the same, wider range, again, of course, prisons, etc. And it's more or less, really looking at the different types of the places of deprivation of liberty. And next. And they have issued reports on restraint beds, protecting prison inmates during COVID, segregation of mental health care institutions, and the status of women, whom they found actually serve under worse conditions than men. Very important, of course, to have a gender perspective on this. Last but not the least is in the Netherlands, we have prisons and psychiatric hospitals, more or less, at the same level. You will see, for example, in 2023, they had more visits to prisons, but in 2024, they visited more psychiatric hospitals. So this is what Ms. Wilson was saying, that the NPMs would really be in more the position to determine, the extent, what kind of places of deprivation of liberty they should be doing. It's in the national hands, not the international. And the reports of Holland really looked at the psychiatric wards and forensic psychiatric clinics. So let me just go to what isn't working. I've given you some aspects about what works based on practice, but there are also things that are not working and that may not work. And this is, as I mentioned earlier, visits for the sake of visits, and as well, too little attention to follow-up. So what really is needed, and only nationals of a country can really come up with this, people who have expertise, credibility, integrity. What is needed is strategic thinking about where our particular national preventive mechanism can really add value, particularly in the light where other oversight institutions are operating. And this should be an ongoing reflection and a focus on change. Next slide. So there are actually three aspects of where the visits can actually contribute. And this actually came up from the Kiev-Copenhagen Declaration on the importance of working across NHRI mandates when it comes to NHRIs who are also NPMs. So the first one is, of course, prevention. That's the whole thing. That's why we're here. But also promotion, and last but not the least, protection. Right? So the promotion mandate, for example, uses an NHRI's promotion department to raise awareness of safeguards. And this they have done in Malaysia. And the protection mandate, next slide. The protection mandate, as an example, in Georgia, the national preventive mechanisms would transfer complaints to the investigation department of the NHRI and also get information back on trends. So, because the national preventive mechanism does not work on individual cases, however, the NPM would be in the position to get complaints from the detainees themselves, because a visit would be, of course, would naturally include not just making an ocular visit, but also talking to the detainees, to the officials, to the prison wardens, whoever is in charge, and they would get some information on complaints, and this they can transfer confidentially to the NHRI. So in here, we can see that there is a complementary aspect with regard to the NPM. So overall, it is about better systems. Whatever the NPM model, whatever the legislature decides, be it a new specialized body, multiple bodies, or be it an NPM embedded or attached, that's a question for the legislators, attached or embedded in the National Human Rights Commission institution, which is the Commission on Human Rights here. Whatever that model, the OPCAT is not only about detainees. It is about making the system, the detention system, work better. So it's a systems approach. NPMs can come with a constructive, solutions-oriented approach. This is where the reports will come in, and they do not blame. They do not wag a finger, you're not supposed to do this. The question here is, how can you do things better? Secondly, the findings, particularly in the reports, help identify what is not working. For example, understaffing, poor infrastructure, unclear procedures on where to have complaints, or where to actually prevent the torture in the very first place. Please remember that even though reports are generally public, however, the sensitive data can be redacted when it comes to specific cases, which can then be transferred to whoever is in charge for investigation, maybe even prosecution. And also there can be also redacted legal or sensitive information depending on the law. The fourth point about systems is better conditions for detainees, which means safer, more sustainable workplaces for staff. Very important to also see that the staff is important in those places of detention. It's not just about detainees. It's also, the system includes the wardens, the guardians, everybody who is concerned with trying to make the place of the deprivation of liberty a safer, more sustainable place. And last but not the least is fairer and more effective justice system, which should build public trust in state institutions. Now, every state has room to improve. This will never, ever be perfect, but we need to ensure that the infrastructure is there, the international standards, the norms, international legal standards are there to be complied with. And this is all not just in the OPCAT, but also what Ms. Marizen Santos mentioned about the Convention Against Torture and other treaties. So just to give you an example, Switzerland joined OPCAT, but has been called out for practice that need to improve. I mean, this is, for a lot of people, very surprising. Because Switzerland, wow, perfect place. Okay? Also very expensive, but it's a perfect place. But no, they needed a lot to do. And I lived in Switzerland for almost 20 years. So for me, even for me especially, this was actually a surprise. But all countries in all regions, including Germany, Argentina, South Africa, New Zealand, have been called out to have actually been called out to improve. So OPCAT, in conclusion, OPCAT is not a tool to expose or to embarrass. It is a framework for continuous improvement. It's supposed to build confidence, not vulnerability, although, of course, the visits should have a chance, important chance, to look at the vulnerable people like women, children in detention, etc. But it has to really signal confidence in terms of its systemic existence, and also states, hopefully the Philippines, that engage openly with preventive monitoring, consistently report
On torture prevention, and for demonstrating how effective preventive mechanism can strengthen institution while protecting human dignity. Maraming salamat. So to continue our discussion on the National Preventive Mechanism, the Commission on Human Rights has launched Bantay Bilangguan as its flagship advocacy campaign to promote the establishment of NPM in the country. To present this initiative and its vision for a torture-free Philippines, may we invite Commissioner Faida Maniri Dumarpa, Commissioner in charge for Prevention Services of the Commission on Human Rights. Comfey.
Assalamualaikum at magandang hapon po sa ating honorable members of the House of the People, aming chairperson, Attorney Richard Palpalato, of course, our partners and colleagues, no? Muli po, magandang hapon. The speakers prior to my time spoke about the National Preventive Mechanism, the UN system, and from my end, allow me to share this Commission's advocacy on the passage of the National Preventive Mechanism from its own lens. No? So, locally po, I will not allow me to skip the second slide. This has been, by the way, I have 8 slides, but technically 6 because the first would be the opening and the 8 would be the closing. So, and I'll skip the first slide as well because this has been thoroughly discussed by the previous speakers. No, we've been a signatory. We've been the state has been obligated to pass the NPM for 14 years now. So, siguro po i-skip ko na ito, no. Very straightforward naman po, obligado ang Pilipinas na isabatas at isakatuparan ang National Preventive Mechanism bilang party, no, state party sa optional protocol na ito. To the next slide, sabi ko nga po, from the lens na commission, we have been advocating, no? We have been advocating for its passage. Of course, ideally, we have national government agencies as our partners, no? Dahil sila po sana yung mga state agencies na tutupad ng obligasyon na ito or mag-advocate, no? But as an NHRI, dahil kami po ay tumitingin at sinisigurado na ang Estado ay tutupad sa kanyang mga international obligations, ito po ay aming isinasagawa. Kami po ay naglunsad ng Bantay Bilangguan. This was launched during the Human Rights Week last year, headed of course by our chairperson, para po sana mapaigting, no, yung pagpasa dahil po sabi nga po natin 14 years na pong pending, no. Of course, ito pong Bantay Bilangguan na ginawa namin, as you have on your tables, we have campaign materials. We've been visiting national government agencies who can become our partners, particularly the DILG, no? Pumupunta po kami dito. Of course, we are thankful, no, to the House of Representatives na this made this dialogue this afternoon a possibility. So kasama po yan sa aming mga advokasya. NPM po, sabi nga po ng aking mga kasamahan, the prior speakers, it's independent, it's advisory, consultative, no, dialogo, no, kasi yun po yung isang mga natatanong sa amin when we do our consultations, when we do our advocacy na baka adversarial, no, ang NPM, no, kokontra lang sa mga places of detention natin, but no, because ang trabaho lang po ng NPM ay yung regular na bisitahin. Kasi nga po, sabi nga po kanina nila, Ms. Marizen, sila Sina, na based on studies, yung regular na visits talagang nakakahinto, no? Isipin mo yung mga officers, mga jail wardens, if alam nila na at any time darating ang NPM, of course, they'll make sure that everything is in order. And I think that's how we prevent torture, no? Yun po yun. So tuloy-tuloy po ang aming advocacy. Ano po yung mga nakikita namin kasi po bumibisita kami like as said a while ago, nag-interim NPM na po kami. We also have our prevention mandate based sa aming mandate sa Constitution and the executive order, no? Ang mga nakikita po namin congestion. As an example po, allow me to share. I think this was in Laguna. There's a detention facility there. If you could imagine, the overcrowding percentage is 3,000%. So, hindi ko alam paano sila natutulog. No, I cannot imagine how they're sleeping. And then, allow me to share as an example again. This is in Misamis Oriental. We visited a mental health facility, and we could not. Magandang hapon po. Kong. Allow me to continue po. Yes, thank you, sir. Another example, may binisita po kami sa Misamis Oriental. Ang meal ng patients po nila, 15 pesos per meal. So you can imagine, I don't think it can even buy a 8-ounce Coca-Cola nowadays. So yung po yung gagawin ng NPM, tulungan po ang ating mga detention facilities, Bucor, BJMP, municipal jails, provincial jails, na mapabuti lalo ang kanilang serbisyo sa pamamagitan ng advisory, sa pamamagitan ng pakikipag-usap. Again, non-adversarial po sila, no? Yun po yung makikita namin. So, of course, next on to the next slide, habang iniintay po natin si NPM, no, ginagawa na po namin ito. Isa po ito sa guidance na binibigay ng aming chairperson na paigtingin ang aming visitorial. In fact, as an example, ang sabi niya po sa amin, ang pagbisita natin, halimbawa may nabisita po, say, example lang po because it's very famous naman, the CIW. When you visit, for example, wag isang beses. Balik-balikan ninyo. Kasi nga mas effective. And that's what we are doing now, no? We look at the data kung saan may medyo mataas yung reports of torture, may mataas na congestion. Yun po yung binabalik-balikan namin. And we hope that this can be continued permanently and more effectively. Mas may karamay kami if the NPM would be established, no? So yung sa mga visits po namin, yun yung ginagawa namin. Out of this, we also furnish a copy of our reports or advisories, recommendations to this very house, no? Senate, government agencies, in the hopes po na matingnan, no, kung ano yung mga gaps and sana po ma-address sila. So, yun po yung ginagawa ng CHR through our prevention services, of course, led by Attorney Regalado here po, nakasama po natin siya. So, siguro po, panghuli sa slide na ito, hindi po magsisimula sa zero ang NPM. Pwede pong magka-transition, and we will be more than happy and honored to, share what we've been doing kung ito po ay maisasatupad na, no? Yun po yung Of course, the necessity for legislation also is the first three reasons for why why we should have the NPM, again from our lens, the Commission on Human Rights of the Philippines, is first legal, no? It's an obligation, it's a commitment. That's the second reason. There is a need to shift our mindset that we act after the fact. It should be prior to the happening of a torture, of a incidents of death in our place of detention. Sana maagapan na po ito. Kumbaga sa gamot ay meron tayong vitamins, meron tayong, instead of addressing a disease that has already happened, no? And it's also more cost effective, no? Mas matipid po ito sa ating budget, sa ating resources. Of course, I'd like to, and allow me to humbly stress that we hope that ito pong National Preventive Mechanism is one of the legacies that this Congress can have, no? Ito po ay isang legasiya hindi lamang po ng ating Kongreso kundi ang ating Executive Department, having said na ito po ay isang obligasyon na matagal ng pending. Secondly, ito po ay para sa ating state, hindi lang compliance, kung hindi, of course, we maintain our good international standing, no? Isa po tayo sa mga bansa sa Asia na halos lahat po ng tratado ay tayo po ay pumirma. no? Kaya lang po, hindi lang po sana hanggang pirma, kailangan po yung gawin din ng obligasyon, no? ng state, no? Of course, for our custodial agencies, we have the DILG, we have the DOJ, our provincial governments, LGUs, no? Magkakaroon po sila ng technical assistance. They could have proper data. For example, na lang po, when we go to our budgets, which is going to happen very soon, of course, you would ask us, ano yung basis mo for requesting an increase on food of your PDLs? If you have the NPM, they would have the data to support, and it's scientific, no? So malaking bagay po ito sa ating mga institutions. Of course, to the person deprived of liberty, kasi po, mas mapapabuti ang lagay nila. There will be prevention of torture, and for me, ultimately, to the community, because their families are outside the places of detention, their children, their wives, their parents, no? So, hindi po ito para sa PDL lang, para sa Estado, kundi sa buong community po natin, no? And like I said, we hope that this is one of the legacies po na pwedeng magandang maiwan po sa ating community, sa ating mga kababayan. And respectfully, to conclude, no, 14 years ago, as mentioned, the Philippines made a commitment. Today, we have a great opportunity to fulfill that commitment. The establishment of an independent NPM is not simply about compliance with an international treaty. It's about protecting human dignity, strengthening accountability, and about ensuring that prevention becomes a permanent feature of our detention system. Through the Bantay Bilangguan, the Commission on Human Rights, led by our chairperson, Attorney Palpalatok, joins all our partners in calling for the passage of a meaningful NPM. Maraming salamat po.
Maraming salamat, Kong Faida. Maraming salamat po. So that's the CHR's initiative on establishment of the National Preventive Mechanism. Commissioner Fido also emphasized the importance or the need to institutionalize preventive safeguard through legislation. So we are through with our substantial discussion. We will now proceed on to the second part of our engagement. So this session shall provide the members of the Congress, even the staff and the other officers here, to engage directly with our resource speakers on the National Preventive Mechanism, its implication, implementation considerations, as well as the path forward. To facilitate our discussion, may I invite Attorney Gemma Parahinog, the Director of Human Rights Policy Linkages Office of the Commission on Human Rights, to take the floor. She will be joined by our resource person as our panelists for this afternoon. So, Ms. Maricen Santos, Attorney Sej Jimenez, Ms. Sina Pulsen, and Commissioner Faida Domarpa. Attorney Gemma.
Thank you so much, Attorney Jill. Muli, magandang hapon po at maraming pong salamat ulit sa ating Committee on Human Rights presided by Congressman Antonino Roman. Magandang hapon po at maraming pong ulit salamat. We also recognize Ma'am Honorable Sarah Jane Elago and Honorable Rene Co. Magandang hapon po. This is a very opportune time already to discuss what our issues and concerns with respect to the legislation of a very important legislation on the part of the CHR and of course on the part of our persons deprived of liberty, the National Preventive Mechanism. We will start I can open now the floor for questions that you may have before our speakers. Again, our speakers are Ms. Maricen Santos, who discussed about the international human rights context, the mechanisms available on the part of the Philippines with respect to the international human rights. Then we have Ms. Sini Paulsen, who discussed the treaty obligations under the Convention Against Torture and the optional protocol and the Convention Against Torture, as well as the role of the SPT, the UN Subcommittee on the Prevention of Torture. We also have Attorney Cecilia Jimenez de Mari, who discussed the best practices in the NPM implementation based on her experience. And finally, we have Commissioner Faida Manili Domarpa, who discussed the CHR's experience with respect to the implementation of its Bantay Bilangguan. We now open the floor for questions. Yes, Congressman Roman.
Well, first, just to update everyone on the status of the MPM bill. Tomorrow, we're going to have the TWG. So we're making headway. Hopefully, we can expedite the approval at the TWG level of the MPM bills. But I do have a question to Attorney Jimenez, ma'am. Is it possible for the MPM to report incidents of torture without necessarily violating its non-adversarial nature and to advocate non-reprisal against persons deprived of liberty?
Thank you very much, Honorable Gatchalian, for that question, because it is actually key to the nature of the National Preventive Mechanism. It is possible, but the reporting will need to be specifically on a confidential basis and only to an entity that would have the possibility for investigation and prosecution. But that is not the main job of the NPM, because as I mentioned, the NPM is there with regard to the system to prevent torture, but any specific cases, this will have to be in the form of complaints from the detainees themselves. And in that way, it can be reported, for example, to the investigation department of the Commission on Human Rights in this particular
Follow-up question, Attorney Jimenez. Have you done that in the past?
Well, many NPMs in the world have done that, and particularly if the NPM is embedded in its NHRI. This is very easy because it will be merely a transfer of the complaint from the NPM, which is actually separate from the rest of the NHRI. It will be a transfer to the investigation. However, for those bodies that are highly specialized, independent from an NHRI, they have actually gone into agreements or memorandum of agreements with the prosecutorial service, for example, or the NHRI of the country. So it will be dependent on the form of the NPM. But yes, it's possible.
Is there such an agreement in the Philippines? How has it been received, like when you reported incidents of torture? How was it received by law enforcement, and also any agreement established with the prosecution?
I think for now there is no official national preventive mechanism in the Philippines. There is an interim NPM established within the Commission on Human Rights, and I would beg your indulgence that probably this question should be referred to the Commission on Human Rights.
And thank you for that lead. So now we turn to the CHR interim, those in the interim NPM, whether you have reported incidents of torture and enter into any agreement regarding prosecution of violators.
May I request Attorney Gil, please, to respond?
Hello, good afternoon. Sir, the Commission on Human Rights, it has its own preventive office, a prevention office. The regional office serves as its implementing arm in the conduct of its visitorial mandate. In the process of preventive monitoring, once we receive reports of alleged torture, we refer them to our protection office or our protection unit. In the regions, we have our investigation unit, which handles our investigation of cases, or at least the validation of alleged cases of torture. So within the Commission on Human Rights, we are able to refer cases of torture. As mentioned earlier by Attorney Sej, it's easier actually for NHRI to have the same mandate. However, we have to consider that a national preventive mechanism is solely, its sole purpose, or at least its primary mandate, is really to prevent torture. So there should be a clear distinction between its preventive and its protection mandate. And I think this is what the NPM, as a specialized unit, shall be addressed if a national preventive bill is passed.
No more follow-up questions? Yes, ma'am.
Maraming salamat po at magandang hapon sa lahat. First question, I'd like to know if there are any efforts to push for the inclusion of the NPM bill in the priority LEDAC measures of the present administration.
Commissioner Dumarpa will respond.
Magandang hapon pong muli. Actually po yung NPM, kasama po siya sa priority legislative agenda ng Commission on Human Rights of the Philippines. And through our Policy Linkages Office, headed by Attorney Gemma Parohinog, we do lobby po sa ating House members, the Senate. Actually, we've been trying to seek an audience po sa ilang kasamahan ninyo sa Kongreso para po sana kami po ay masama sa LEDAC. So it's an ongoing process, pero we have yet to be included, no, including the charter of the CHR sa atin pong priority bills po. Thank you po.
Maraming salamat, Madam Facilitator, Mr. Chair. What about Malacanang po, the Office of the President? Has there been any guidance as to how we can move forward into having this prioritized by both houses? Kasi po nakaka-apekto din yun if it's part of the list of LEDAC, no, malaking bagay po na nabibigyan din po ng atensyon ng ating mga committees.
Attorney Gemma?
Yes. Actually, we have before requested that the priority human rights legislation of the Commission on Human Rights be part of the LEDAC. That includes, of course, the NPM. In our engagement before with former Executive Secretary Bersamin, we have written a letter and they have responded that we should secure first a complete staff work, securing with the DILG, of course, being the lead agency for the implementation of the Convention Against Torture. We have been securing the support of all agencies, executive agencies, if they have any issues with respect to the legislation of this very important measure. So far we've been doing that, although in the recent changes in leadership, not only in the executive but also in the legislative, there's been a stall in the process, but we're continuing with the new leadership. We've been engaging the DILG first and foremost, and of course, we've sent a letter already to the Executive Secretary, the current Executive Secretary, seeking for an audience so that we can discuss all the priority legislative measures of the Commission.
I asked that question, Madam Facilitator and Mr. Chair, because perhaps the members of the committee led by the principal authors of the NPM bill can write to the Office of the President and our counterparts in the Senate to really have this prioritized. Ngayon po patapos na, pero perhaps in the next year, isa po ito sa masama sa mga prioridad ng ating mga kasama. Ngayon naman po, has the CHR reviewed the most recent working draft of the NPM bill? Would you say that now in its current form, masasabi na po natin na it is an OPCAT compliant legislation?
I can respond, but
Kailangan po namin to kasi to guide us tomorrow sa technical working group. Opo, para makita po namin kung ano yung dapat naming bantayan, especially with regard to independence and resource allocation. Kasi sometimes mahirap po kung maipasa ito pero wala namang pondo. Mahirap din pong gumalaw.
Commissioner Faida po will respond.
Yung original draft po, Chair Kong, actually came from the Commission on Human Rights. And when we drafted the proposed legislation, we ensured na it's a human rights-based approach, it's compliant to what the OPCAT requires. Yun po yung aming po. So we're hoping po if what has been considered before the House would be the proposal, compliant po iyon, Kong. Yes.
Maraming salamat po.
Just to add po, Kong, to share, we have discussed initially before with Commissioner Faida with some of the authors, for example, Congressman Rufus Rodriguez. We've had a session with him to discuss the NPM. Of course, with Chair Bienvenido Abante, we have discussed our proposal for the original draft of the bill, and some of them have been adopted and sponsored by the plenary. And I think with reference to your former question, also, I think Congressman Abante actually requested us to submit a justification for inclusion of these priority measures so that he will sponsor it for inclusion in the LEDA. I think that's his commitment already through us, so we will be complying. Congressman.
Sige po, maraming salamat po, Mr. Chair, Madam Facilitator. Last week din po, kakabisita lang po namin sa CIW. Tapos nakatanggap po kami ng maraming sulat tungkol sa mga terminal ill na mga patients, mga may stage 4 cancer na nakahalo din po sa iba at wala pong timely na access to treatment. Ayun. Kaya po, siguro po, sa labas na po ng discussion na to, pero susulat po kami sa CHR pagdating po sa mga nakalap po namin na mga issues na maipaparating po natin sa ating commission. Maraming salamat, Mr. Chair. Yun lang po muna dahil magpe-plenary session na rin po. Thank you.
Meron akong tanong po sa HR. Sa Senado po, sino ho who's the author in the Senate of the NPM bills?
Si Senator Estrada and si Senator Lapid.
And what is the status of the bill in the Senate right now?
They have not scheduled a hearing at the committee.
Have you reached out so it can be calendared for discussion?
Yes, sir. Through our chairperson, he discussed it with the former chair of the Committee on Justice and Human Rights, for Senator Pangilinan before. So we were just waiting for it to be called for hearing, the NPM bill, including the CHR charter, of course. But things happened.
Opo. Sabihin niyo, bilisan nila, maunahan namin sila.
Ganun nga po nangyari ng 19th Congress.
Mauna kami. Bukas yan, tapos na yan. No, I'm just, it's a wishful thinking. But we'll try.
Kong, if it will help, during our discussion with Senator Pangilinan, actually, during that time, he was the chair of the Committee on Justice and Human Rights of the Senate. His commitment was, as soon as the version of the House reaches the Senate, they will just adopt the version. So that was his commitment then, when he was the chair. But as Attorney Gemma said, things happen. So
Thank you for the update. I just felt the pressure. You put the pressure on us. Maraming salamat. That means we really have to move things along in the next few weeks.
For the floor now to Attorney Jill.
Thank you very much, Attorney Gemma. And just to add siguro sa question kanina, and Congressman Roman is here, he has been convening the technical working group, and we're very much appreciative, sir, for your effort that continue po siya. However, katulad na na-mention earlier ni Commissioner Fay, that the initial draft is OPCAT compliant, but there are several comments that are coming in, and yung kailangan po siguro nating pantayan, Vice Chair. Yan. Ayun po. And thank you very much, Director Gemma. To deliver the synthesis of today's discussion and call for the continued legislative action and solidarity, may I invite the Executive Director of the Commission on Human Rights, Attorney Jacqueline Ansi de Guia, to give the closing remarks and our call to action.
Thank you, Attorney Jill. Distinguished members of the House of Representatives, headed by Vice Chair Honorable Antonino Roman III, officers and staff of the House of Representatives, Representative Honorable Sarah Jane Elago, partners from the international community, colleagues from the CHR, ladies and gentlemen, magandang hapon po sa ating lahat. As we close today's dialogue, allow me to express in behalf of Chairperson Richard Palpalatok and Commissioner Faida Manirido Marpa our sincere gratitude to everyone who made today's gathering meaningful, substantive, and hopeful. Kongreso para sa Preso is more than a forum. It is a collective affirmation that the dignity of every human person, including persons deprived of liberty, must remain at the center of our democratic institutions and our justice system. This afternoon, we heard valuable perspectives that strengthened our understanding of why the NPM is both a legal obligation and a moral imperative. From the session on the international human rights context, we were reminded that the prevention of torture is not merely a policy aspiration, but an internationally recognized duty anchored on universal human rights standards. From the discussion on treaty obligations and the role of the UN Subcommittee on Prevention of Torture, we were reminded by SINA that after more than a decade since our accession to OPCAT, the absence of an enabling NPM law remains a critical gap that must now be urgently addressed. The technical session on best practices and NPM implementation by Attorney Sedge showed us that effective and independent NPMs are not abstract concepts. The experiences today demonstrate that prevention is possible, practical, and transformative. The open forum perhaps became the most important space of the afternoon. Here we witnessed genuine engagement between legislators, international experts, and human rights advocates. Questions were raised not only about compliance, but also about implementation, sustainability, and institutional collaboration. This exchange reflects an encouraging reality that the conversation on the NPM is no longer confined to advocacy circles. It is now firmly within the sphere of legislative action and national policy reform. And this is precisely the objective of this dialogue. This gathering was envisioned to strengthen legislative support for the pending NPM bills, deepen understanding of international standards and obligations under OPCAT, and reinforce the shared responsibility of Congress and the CHR to protect human dignity and prevent torture. We hope that today's discussions will translate into concrete and sustained legislative action toward the establishment of a strong, independent, and effective NPM. To our legislators, we respectfully urge your continued leadership and support in advancing this important reform. As your partners in this advocacy, the CHR remains fully committed to working with Congress, government institutions, civil society, and international partners to help realize a human rights-based, humane, and accountable system of detention and prison oversight in the Philippines. Before I end, allow me to extend our deepest appreciation to our resource speakers and partners who generously share their expertise and solidarity with the Philippine human rights community. To the Office of the United Nations High Commissioner for Human Rights and the Association for the Prevention of Torture, maraming salamat po for standing with us in this advocacy. We likewise express our profound gratitude to the Embassy of the Netherlands for its invaluable support to human rights and torture prevention initiatives. To the House of the Representatives Committee on Human Rights, under the leadership of Congressman Bienvenido Abante Jr., together with Committee Vice Chair Kong Antonino Roman III, thank you for opening this space for dialogue and for demonstrating your commitment to legislative reforms that protect the rights and welfare of all Filipinos, including persons deprived of liberty. Finally, we thank everyone who participated today, Honorable Renil Luis Co, Honorable Sarah Jane Elago, and all the representatives who were present a while ago. Thank you for opening the space for dialogue and for demonstrating your commitment to legislative reforms. The work ahead remains challenging, but today reminds us that meaningful reform is possible when institutions, advocates, and lawmakers unite with a shared purpose. Let us move forward with resolve and solidarity, committed to ensuring that no person is subjected to torture, abuse, or degrading treatment, and that the dignity and humanity of every person deprived of liberty are always protected. Again, maraming salamat po at mabuhay tayong lahat.
Maraming salamat, Edie. Maraming salamat muli sa Committee on Human Rights ng House of Representatives. May I invite everyone for a picture-taking po sana before we go. Maraming salamat po ulit. Vice Chair, maraming salamat po kay Chair.
ibang